are present, I declare the motion passed. The new 4A and the new 15A. The new 4A Section 15 amended non-admissibility, etc. of instruments not duly stamped. The new 15A Section 47F amended relief on transactions under qualified investment arrangements. Secretary for Transport and Housing. Mr. Chairman, I move the second reading of the new 4A and the new 15A. The amendments have already been set out in the paper circulated to members. For Section 4A, this is to provide for the admissibility of instruments not duly stamped with the BSD if certain conditions are satisfied. Under the Stamp Duty Ordinance, Section 15 says that instruments not duly stamped with stamp duty should not be admissible in certain proceedings. In order to respond to the concern of the Hong Kong Law Society and the Hong Kong Association of Banks, they are of the view that even if the buyer hasn't paid the BSD, the innocent party should not be affected. Say, for example, the seller has no responsibility to pay the BSD. In particular, their right to produce the relevant documents in proceedings. The administration is now proposing a CSA so that instruments not duly stamped with the BSD, if the instrument is to be produced by a person other than the buyer, then it can be admitted by the court in a civil proceeding. This is consistent with the policy intention of the right not to affect the innocent party. For the new 15A, this is to tie in with the Inland Revenue and Stamp Duty Ordinance, Alternative Bond Scheme Amendment Ordinance. It is a consequential amendment. On the 19th of July 2013, the Inland Revenue and Stamp Duty Ordinance Alternative Bond Scheme Amendment Ordinance provides for a similar taxation regime in relation to some commonly seen Islamic bonds in relation to the tax liability of profits tax, property tax, and stamp duty. For that particular amendment ordinance, it provides for relief on stamp duty and special stamp duty. However, at that time, the BSD has not yet been included in the SDO, and therefore that amendment ordinance cannot provide relief for those types of tax. In order to achieve consistency in relation to stamp duty relief and to respond to the views of the members of the Bills Committee on Inland Revenue and Stamp Duty Ordinance Alternative Bond Scheme Amendment Bill 2012, we are now making a consequential amendment so that the relevant documents may be given relief from BSD. The Inland Revenue and Stamp Duty Ordinance Alternative Bond Scheme Amendment Ordinance, Bills Committee members also agree to such an arrangement. Mr. Chairman, the above-mentioned new sections have already been scrutinized by the Bills Committee, and generally speaking, they have the support of the members. I hope members can support the above-mentioned new sections. And now put the question to you, and that is the new 4A and the new 15A be read the second time. Does any member wish to speak? Mr. James Toh. Mr. Chairman, for the new Section 4A, mainly speaking, the Law Society of Hong Kong and the Hong Kong Association of Banks raised a concern. I think the original idea wasn't just about Section 4A. In other words, for instruments not duly stamped, as long as certain conditions are met, then it is suggested that such instruments should be admitted in certain civil proceedings. as long as they are not produced by people who haven't paid the tax. Now, in fact, the Law Society of Hong Kong and the Hong Kong Association of Banks would like to go one step further. For stamp duty, the liability should have fallen on the seller only, and for the buyer's stamp duty, the liability falls on the shoulder of the buyer. So it is very clear that we should go after the buyer in relation to the failure to pay the BSD. But then the administration is of the view that for the SDO, under the SDO, in fact, both parties could have been made to bear the responsibility. So the administration would like to keep the possibility that in extreme conditions, the seller would be asked to take up the liability. Now, the administration is not going to compromise in relation to the first condition. Now, say, for example, there is this property. It has changed hands a number of times, and now it has been mortgaged with a bank. When the bank has to use the documents to get back the loan, now the bank is now going after a party or parties who are several times away from the original transaction for which stamp duty hasn't been paid. Now, the title and the relevant documents have to be produced in court. Now, somehow, maybe the borrower comes up with a brilliant idea. He may point out that for certain documents, it can be seen that they haven't been stamped with the BSD. So in this case, the documents cannot be admitted in court, and then the bank will be rendered in a very disadvantageous position. I try to think about the scenario carefully. Now, if we are talking about many transactions before the relevant one, and if that previous one was the one not stamped with the BSD, the bank may very well choose not to produce that instrument. But for the final buyer, maybe he has borrowed money from the bank and yet he is not repaying the mortgage, and so the bank is going after him. Now, say, for example, a few transactions beforehand, it is found that a particular instrument hasn't been duly stamped. I just wonder whether there are already sufficient documents to make sure that the person involved must repay the creditor. I want to find out, when the court studies the matter, whether this point will be considered. Of course, finally, the buyer has already bought the property and has been mortgaged with the bank. Now, for that particular deed or that particular title, whether it is a good title, and since it has been mortgaged with the bank, and the agreement of the loan and also the mortgage deed must be very clear. Now, the bank may now say that it is not a good title. Maybe the bank has no longer got the collateral, but the money owed should still be a liability that has to be discharged. So I want to know whether the document not duly stamped must be covered and can only be admitted with this exemption. Of course, in the eyes of the HCAP and other people involved in dealing with such instruments, they want to be given certainty. They want to be covered in all scenarios so that the instruments not duly stamped can still be admitted. So I agree with the administration's proposal to exclude or to exempt this sort of instruments. What is mind-boggling is that even if the HCAP would like to exempt such instruments from the non-admissibility. Now, it is said that there should be a provision so that with value and bona fide residential property transactions, parties to such transactions, including the buyers, will be covered. Now, the HCAP is now putting forward two arguments. That is, there must be a bona fide purchaser for value. In other words, a consideration has been paid and it is a bona fide transaction, including the person who takes out the mortgage. However, what is mind-boggling is that for the proposal made by the administration in relation to the new section, with value and bona fide are not being included in the exemption sought. Earlier on, at the Bills Committee meeting, I reminded the administration of the omission of such words. I've told the administration that it is fine for them to seek an exemption. Maybe a number of transactions later, the bank has to deal with this instrument and the bank is innocent. But then we have to make sure that it is really the innocent party. Otherwise, there may be the possibility that the buyer who hasn't paid the BSD is somehow associated with the bank, or there's a collusion between the two, so that the failure to pay the BSD together with the interim transactions may cause a problem, and I don't think that we're justified to allow for an exemption from the admissibility rule. Now, at common law, we may have the third party who is a victim, and we have to make sure that it is a matter which is bona fide and which is with value. Say, for example, you may have bought something which are stolen properties. Under specified scenarios, you have no knowledge that it is stolen property, and in some cases, you will be exempted from the liability from the original owner, because in this way, the normal commercial operations can still go on. This is a commonly seen concept, and the HCAP must have lawyers to advise them. If they want the administration to give certain exemption in certain scenarios, I think they should have narrowed the scope, and it is reasonable and it is restricted. I don't know why the administration has been so generous as not to include the reference to with value and bona fide. I don't know why the drafting hasn't included two elements. I've reminded the administration to include both elements. Well, to be frank, when I first proposed the idea, I could not remember whether the HCAP has referred to such. I read the papers again, and I found that, in fact, the HCAP did refer to the two elements. They knew that they had to be included, but I don't know why the association, on the other hand, has been so generous. Not that I want to narrow the scope of the exemption, but if the HCAP has got new legal advice, and if the HCAP has already considered the matter thoroughly, and if they believe that only those with value and bona fide should be given exemption, then I don't think the government is justified to do otherwise, unless the administration has got a good reason.
But so far, in the amendment proposed by the administration, it has not explained why it's being so generous. I remember there was one meeting that I couldn't attend because it clashed with another meeting in another room. By the time I came back to the meeting, the whole discussion was over. But I checked with other colleagues. It seems that the administration never gave an explanation. Now, we are towards the end of this consideration of this bill, but to be fair, the administration should at least give its official position and explain why. Even the Hong Kong Association of Banks has not asked for such a wide exemption, and you are offering this or granting this wide exemption. This is an amendment on Section 15A, the alternative bond schemes. That's usually what we refer to as the Islamic bond scheme. This Inland Revenue and Stamp Duty Legislation Alternative Bond Schemes Bill, or this Islamic bond scheme. What is the direct relevance between this Islamic bond scheme and the stamp duties we are considering here? The administration is only saying that because we've been granting such exemption, that's why we are proposing these amendments. But then it's never explained in detail which provision it is. Why is there a need to make this consequential amendment? You've only given us some broad concept, but you haven't provided the specifics. Now, I don't recall the Bills Committee considering this in detail, but perhaps because you all trusted the government, but at least the administration should tell us why. In relation to the Islamic bond scheme, it is essential and it is right to move this consequential amendment here in this part of the bill. Otherwise, we can only take your words on trust. Of course, if there will be major impact, you must make the consequential amendment. But, you know, this consequential amendment, which part of the bill is it about? And if there is not such a consequential amendment, how may it affect the Islamic bond schemes? Under what circumstances will people have to pay the special stamp duty and the buyer stamp duty? If you say that it's possible that for other general stamp duties under the stamp duty ordinance that constitute one scenario, but then perhaps for Islamic bonds, there are other circumstances that might lead to the payment of stamp duty. Now, I actually don't follow. And it's even harder to understand why there is a need to pay buyer stamp duty. Well, there is the Deputy Secretary here with the Secretary. So I think to play safe, you have to explain why this is an essential consequential amendment. Please give us an explanation. Mr. Kenneth Leung. Thank you, Mr. Chairman. New Section 4A and new Section 15A, they are both technical amendments. Of course, at the Bills Committee, not many members would be interested in looking at technical amendments. For these two technical amendments, I put forward a lot of views, but it seems that the administration wouldn't take on board my views, or it actually was reluctant to answer my questions. When these technical amendments were proposed, I already asked this question of the administration. Stamp duty as a type of tax. Now, in the 15th century, the Dutch people started sea trade. They needed tax income so the country could build more ships. They invented this tax type called stamp duty. That is, when you want to execute an instrument, for the instrument to be valid, it must be stamped. So that means you have to pay stamp duty. So that was the earliest type of stamp duty in Europe. Europeans actually invented other tax types as well, such as they could tax on the number of windows the house had. So for stamp duty, you only need to pay a duty when there's an instrument. It's not based on the consideration. It's not based on a transaction. Rather, it's based on an instrument. Now, we've had stamp duties for a long time. And under the stamp duty ordinance, we have the general stamp duty, we have SSD, we have BSD. Later on, we will have the DSD. So there are different types of stamp duty. And they're used as demand-side management measure. in terms of the law, in terms of the technical aspect, is actually not desirable. Because for one type of tax, there could only be one approach. If you look at the so-called SSD, it's actually very similar to a capital gains tax. As BSD is similar to a turnover tax. So why do we need to give special treatment to Section 4A? It's totally mind-boggling. Is it because the Hong Kong Law Society or the Hong Kong Association of Banks wrote a letter and then the administration said, okay, then we take the middle-of-the-road approach. We took on board some of the suggestions, but not all. Now we're talking about usual property stamp duty. In the stamp duty ordinance, the basic provision is about buyers paying stamp duty. I'm talking about the general stamp duty. But then there is another provision that says,
be jointly and severally liable for the stamp duty. 嗱，當然喺普通情況底下，如果稅局可以追收翻。
So under normal circumstances, the Inland Revenue Department may try to recover stamp duty from buyers. It's like stock transaction, 0.2% of the stock transaction levy. Both the buyer and the sellers have to pay this stamp duty. But if the Inland Revenue Department could not collect the 0.1% from either the buyer or the seller, because the seller or the buyer has fled or not traceable or is not traceable, then the IRD could recover the 0.1% from the other party. In other words, one of the two parties would have to pay the full stamp duty. So whether it's the SSD, BSD, or DSD, it shouldn't change this kind of arrangement because we're just talking about one type of tax that's called stamp duty. Now we want to maintain a simple taxation regime. Let's say for stamp duty, you're using it for another purpose, in this case, demand side management, then of course you're complicating matters. Mr. James Toh referred to instruments not stamped with SSD or BSD. In theory, these instruments would not be admissible in civil proceedings. That is spelled out clearly in the stamp duty ordinance. But then there is another provision that says that with the exception of criminal proceedings, for these instruments which have not been duly stamped, that is, not all or part of the stamp duty has been paid, these instruments would be admissible in criminal proceedings, rather. So if you haven't paid the BSD or ASD or other stamp duty in full, if this amendment that for the innocent party, if it hasn't paid the full stamp duty, then it shouldn't affect the admissibility of the instrument. But couldn't there be a better approach? For example, the court should be allowed the discretion to consider this matter, because SD, SSD, or BSD, they're actually all the same type of tax. So I don't see why for SSD or BSD there should be a separate exemption. Why should there be such a case? Because all these are stamp duties. Now, SSD and BSD are actually not SD. The government is now coming up with a different type of tax, like capital gains tax or turnover tax. You could have come up with such taxes. You could still use them as demand-side management measures for the property market. For the alternative bond scheme, the administration has not explained in detail the technical amendments. Now, the alternative bond scheme is given exemption from profits tax under the Inland Revenue Ordinance and stamp duty from under the stamp duty ordinance. Now, before we completed the scrutiny of the Stamp Duty Amendment Bill 2012, the other bill was passed, that is the Inland Revenue and Stamp Duty Legislation Alternative Bond Schemes Amendment Bill 2012. I was a member of that Bills Committee, and this bill was to give issuers of alternative bonds. Now, actually, it's about Islamic bonds, but although we don't refer to the schemes as Islamic bond schemes. Now, when there is transfer because of the need to comply with the Sharia law. Well, the Sharia law is actually not a law as such, because there's such law could be interpreted by the churches. But anyway, in terms of stamp duty or profits tax, we do not recognize them as transfers. So in the context of the profits tax or stamp duty, we would not charge profits tax or stamp duty. Why is it that in Sharia law, in the alternative bond scheme, there is a need to have these different types of transfer? Firstly, it's because in the Islamic teaching, nobody must gain something without making an effort. In other words, we can't just borrow money or lend money to someone, and I can't collect interest without making an effort. I can't make the gain. So you have to do a business or do something before you get a return. So when we issue bonds, there is a need to set up special vehicles, overseas vehicles, for instance, so that Islamic bonds could be issued. Now, for the ordinary stamp duty, we've already catered for the alternative bond schemes. I'd like the administration to confirm as far as Section 15A amendment is concerned, because Mr. James Toh just asked a question too just now. Now, for for the Islamic bonds, if there's any transfer without any commercial value and is in line with the principles of the Sharia law, then we do not regard that as transfer. So in terms of SSD or BSD, it will not be payable. Can I ask the administration to clarify this point in response to my question? Now, when before the Alternative Bond Schemes Bill was passed into law, I understand the Inland Revenue Department would vet these alternative bonds case by case, whether in terms of profits tax or stamp duty payable or not payable. So I'd like to seek more information. The SSD, the new stamp duty, its time limit, its coverage, and BSD is another new tax type also. Before this bill is passed into law, has the IRD ever dealt with cases? In these cases, perhaps the issuers of alternative bonds or actually Islamic bonds, they have to apply to IRD for special exemption. Has the IRD ever dealt with such cases? And if it's received such applications, how many were there? I'd like to know. Here, if we're talking about the usual stamp duty, the IRD has dealt with these cases individually. For the SSD and the BSD, another new tax type, we haven't received any information if the IRD has ever dealt with such exemption cases. Actually, for BSD and SSD, already the law firm has withheld the money. Then the RD should have issued some documents, perhaps not a technical guidelines, but it should have explained to banks or the relevant parties how BSD and SSD could be exempted as far as the alternative bond schemes are concerned. But I did not see the IRD having issued any such guidelines, Mr. Chairman.
No.
So, in short, I think using stamp duty as a means of demand-side management against the backdrop of a low-tax regime, such as in Hong Kong, we are building a very complex mechanism on top of it, because we're not talking about levying duties on instruments. And these duties can be subject to upward or downward adjustments, and by doing so, we seek to manage demand. But why can't we develop new forms of taxation instead? And the stamp duty ordinance, in fact, is quite difficult to understand already at the moment as it stands. But now it's getting even more complicated because it covers 4 tax types, each having their own characteristics. Now, in terms of the laws, I hope the administration would think about it. The DST will be coming soon. In terms of technical issues, I hope the administration can be consistent. If there are 4 tax types, in terms of civil or criminal evidence or even exemptions, there are different approaches to how they should be handled. Then I'm concerned, even for experienced lawyers or accountants, they might mix them all up. This is important to maintaining ourselves as an international financial center, to maintain our competitive edge, to maintain a simple and easily comprehensible tax system and a legal system. This is very important. I so submit, Mr. Chairman. Does any other member wish to speak? Mr. James Toh. Chairman, for 4A, regarding admissibility, I wish to explain to everyone what the problem is. For example, for buyer stamp duty, now, exemptions will be given to Hong Kong permanent residents, and they're not required to pay the BSD, and what they need to do is to take an oath, and after doing so, they can pay the general stamp duty rates and have the instrument duly stamped. But for subsequent purchases, it's difficult for them to find out in terms of previous transactions. In particular, buyers who bought the property after the BSD comes into effect, whether they have paid the stamp duties or not. They may not be Hong Kong permanent residents, which means they will be required to pay the BSD. My point is, the exemption should not be so wide in scope, and I can give you this example. If he's not a bona fide purchaser, for example, if this person, having taken an oath, claims that he should be exempted from BSD, but in fact he's non-Hong Kong PR, and then after 2 more transactions, the purchaser becomes a bona fide day 1, that means that he will not be subject to BSD, then there will be an incentive for him to convey the property to another person. You must bear in mind that I might not take out a mortgage from a bank. I might pledge it to Wuchiwai, and according well, this then, and by then, this could be a good title. And bona fide purchaser with value means that we're trying to prevent fake mortgages, such that by not paying the mortgage installments, the property can be put up for auction, and by doing so, to regularize or make it legal for someone not having paid BSD in such circumstances. If we don't rely on Section 4A, if we rely on the court in exercising discretion in admitting evidence, I think comparing to this scenario in terms of admissibility, it is more cautious, because now that we have SSD and BSD, and for BSD it's more risky, because for special stamp duty, as long as you check the purchase date and the selling date, and then we check the applicable laws at the time, we can calculate whether the SSD rates are applicable. However, for BSD, because exemptions could be given, and if the exemption is granted under a scenario in which somebody falsely takes an oath, then eventually, when someone wants to admit or wants to adduce this evidence in court, he might be caught in a difficult situation. So, for bona fide purchaser with value, the common law concept, as proposed by the Hong Kong Association of Banks, is quite a steadfast concept. But on the other hand, we may also set out broad principles for law courts to follow. As long as they follow the general principles of equitable and coming with clean hands, then courts can exercise their discretion in deciding whether to admit such instruments as evidence, whether or not the new forms of stamp duties have been paid. I think this is more appropriate. Is there any example in which courts can exercise discretion in admitting inadmissible evidence? Now, colleagues may not be familiar with these cases, so I won't dwell into these cases. For example, in admitting criminal evidence, or adopting statements as evidence, or under certain scenarios, whether the evidence is fair to the plaintiff and the defendant. And there are many principles, many authorities for courts to follow. And if we allow courts to exercise discretions, then under various scenarios, as long as the principles are upheld, discretion may be granted or may be exercised to decide whether the instruments which is not duly stamped can be admitted or not. So perhaps Secretary can explain to us why it's drafted in such a manner, and it's even broader than that proposed by the Hong Kong Law Society and the Hong Kong Association of Banks. Does any other member wish to speak? Secretary. Mr. Chairman, thank you, Mr. James Toh and Mr. Kenneth Leung, for a very detailed introduction to stamp duty and other issues, including the features of the Islamic bonds. I will give a more detailed reply here, as mentioned by Mr. Kenneth Leung just now. Indeed, stamp duty was invented in Holland under the Roman law system, and over centuries, indeed, stamp duties could be applied to various areas. For example, for postage stamps, this piece of stamp is regarded as a consideration for the fees to post a letter. But now we also use the same word stamp in representing that the authority has duly recognized this instrument as a legally binding instrument. That is, the authority with legal binding effect recognizes this instrument as valid. And be it a tenancy agreement or sale and purchase agreement, this instrument must be acknowledged. That is, it must be duly stamped to show that the government has perused this instrument, and it originates from in Europe, and it has a long history. So Mr. Kenneth Leung just now asked why we should not just use the traditional ad valorem duty. That is, as long as... Yes? Sorry, the speaker is not using microphone. Secretary, please pause here.
The Secretary. Mr. Chairman, I will continue. Just now I mentioned the ad valorem stamp duty, and it is based on the amount of the value to charge the duty so as to confirm the transaction. Generally speaking, in relation to the tax liability of stamp duty, it used to be the jointly and severally liability of both the buyers and the sellers. But of course, both parties can agree on a way acceptable to both in order to share the liability. Now, we are here pinpointing the buyer. This is because we are talking about the BSD, the buyer's stamp duty. So there is this doubt as to whether the seller has to bear the responsibility as well. If the buyer hasn't paid the BSD, it is asked as to whether the instrument is still acceptable. Mr. Leung asked, the origin of the stamp duty is no longer consistent with the current use. And so he asked why the stamp duty is being relied upon as a demand-side management measure. Whenever we talk about the property market, yes, we can resort to different types of taxes, but then the use of the stamp duty is not an exception. In Singapore, they have the additional buyer's stamp duty, and it is also being used as a management tool for the property market. Mr. James Toh also asked for the criteria for confirming as to whether a transaction has been a bona fide one. Well, looking back, we did offer this explanation at the Bills Committee meeting. In its early days, the stamp duty was such that instruments not duly stamped should not be admitted in courts. To answer the query from the Law Society of Hong Kong and the Hong Kong Association of Banks, we should not affect the innocent parties' right, and therefore we would like to have this proposal that is, we should allow certain instruments, though not duly stamped, in certain circumstances, they should be admitted in civil proceedings. At first, we said that perhaps, first of all, it's not produced by the buyer. So as to prove the ownership of that person, or it should be produced by the seller so as to enforce the instrument. Secondly, this instrument has been registered with the Lands Registry. Thirdly, the buyer has given a false representation saying that he's a Hong Kong PR or he's acting on his own behalf. That was the original form of the amendment. And then the Law Society gave us further opinions. The Law Society said that this was meant to respond to the profession's concern about the applicability of the BSD. But then the Law Society was worried that in accordance with the original form of the amendment, there might be other problems arising. Say, for example, after signing the agreement, if the buyer doesn't pay the BSD and dodge away from completion of the transaction, now the instrument hasn't been duly stamped. In other words, it cannot be registered with the Lands Registry, and then the innocent party cannot rely on the government's amendment to produce the document because the buyer hasn't stamped the BSD. Moreover, the innocent party would find it difficult to prove that the buyer has made a false declaration. And then the Law Society agreed to do away with 2 out of the 3 conditions. The only one left is that as long as that person is other than the buyer. So it's not that we have become generous all out of a sudden. This is merely to respond to the Law Society of Hong Kong's concern. During the scrutiny of the CSA, the legal advisor of the LegCo noted the point, and he has no other disagreement, and no other members have strong views concerning the matter. The second point is about the Islamic bonds. I want to say that for the Islamic bonds, they are indeed very different from the traditional bonds, because according to the Sharia law, we should not collect interest. According to the Islamic laws, if you have a bond to represent another person, and then you can sort of share the dividends, and that would be similar to the interest. So in substance it may be similar, but then in terms of the presentation it is different. So when compared with the traditional bonds, the structure of Islamic bonds is more complicated and different from the traditional bonds. According to our tax regime, we have been basing our tax regime on the traditional bonds, and we have been using the terminologies, and we use the same criteria. In that case, profits tax, property tax, or extra stamp duties may become liable for the Islamic bonds. You know that for the past few years we have been promoting the market of the Islamic bonds in order to remove the hindrance, and we have made reference to the practices adopted by other countries in promoting Islamic bonds. Therefore, we have amended the Inland Revenue Ordinance and the Stamp Duty Ordinance, so that in terms of the number of taxes, we are providing a similar taxation framework to Islamic bonds like traditional bonds. So for a valorem stamp duty, special stamp duty may be subject to certain relief. And for the BSD, we would like to apply the same principles, and so we've been consistent, and we want to make sure that we can facilitate the promotion of the Islamic bond market. Just now, Mr. Leung asked about the ABS as to whether the IRD has already accepted any applications for tax relief. The answer is in the negative, but then the IRD has already come up with the guidelines for the operation of the bonds. I'll now put a question to you, and that is the new 4A and the new 15A be read the second time. For those who are in favor, please raise your hands. Mr. James Cho claims a division. The bell will ring for 5 minutes.
Voting begins. Please check your votes. If there are no questions, voting is closed. The results are displayed. Voting results: 50 present, 48 for, 1 against. No abstention. The question is agreed by a majority of the members present. I declare the motion passed. New Section 4A and 15A, Secretary for Transport and Housing. Mr. Chairman, I move that the new Section 4A and 15A be added. I now put a question to you, and that is the new Section 4A and 15A be added to the bill. And I'll put a question to you. Will those in favour please raise your hands? Mr. James Ho claims a division. The division bell will be rung for 5 minutes. Voting begins. Please check your votes. If there are no questions, voting is closed. The results are displayed. Voting results. 52 present, 51 for, no against, no abstention. The questions agreed by a majority of the members present. I declare the motion passed. I adjourn the meeting till 9 a.m. tomorrow.